2014, a landmark decision was made regarding companies with excessive numbers of light-end executives. Specifically, it concerned a company with a total of 108 light-end executives. The company in question was a bank in North Rhine-Westphalia. These supposedly light-end employees were represented by the law firm Kliemt before both the Mönchengladbach Labor Court and the Düsseldorf State Labor Court. Ultimately, the Düsseldorf State Labor Court found that only 18 of these employees were actually light-end executives under works constitution law. The remaining 90 employees are to be regarded as non-light-end employees under applicable law. The employer and the law firm Kliemt tried until the end to convince the court of the high managerial quota in this company, apparently without success. The Federal Labor Court in Erfurt ruled on this back in 2001 and based its decision, among other things, on the hierarchical levels in the company.
The lower the specific decision-making level in the company hierarchy at which the employee fulfills corporate or managerial tasks, the greater the probability that significant entrepreneurial decision-making scope has already been used up at the higher decision-making levels.
With this statement by the Federal Labor Court, the Düsseldorf State Labor Court came to the conclusion that from the third level behind the management board, it could be assumed that significant entrepreneurial decision-making powers had been used up. It literally stated,
accordingly, the above-mentioned department heads, department directors, and Mr. D cannot be regarded as executive employees within the meaning of paragraph 5, section 3, sentence 2, number 3, Works Constitution Act. They are all on the third hierarchical level from the top. For this reason, it must be assumed that significant entrepreneurial decision-making leeway is used up at the executive board level, or at the latest at the level of the division manager. However, it is not clear from the employer's entire submission in both instances which individual competencies remain where the employees are essentially free to make decisions.
The Düsseldorf State Labor Court ruled that only those employees who reported directly to members of the company's executive board were also deemed to be light-end employees. The other employees are protected by works constitution law.
All of the above-mentioned employees report directly and immediately to the executive board. They report directly and necessarily to the members of the executive board to whose department their area belongs, and are therefore responsible for the decisions and measures they take in their respective areas of the company.
This had significant consequences for the personnel structure in this company, particularly with regard to the rights of the supposedly light-end executives. A groundbreaking judgment around 10 years ago. Nevertheless, there are still companies and organizations today that have even higher ratios of senior executives. We have already reported on this in an earlier video. We will continue to keep you up to date on this important topic and many others. See you soon.